Now, Article 1, Section 9, Clause 2 of the U.S. Constitution, habeas corpus. The privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. President George W. Bush suspended writs of habeas corpus through the Military Commissions Act of 2006, which granted the president authority to establish military commissions and barred unlawful enemy combatants from challenging their detention in court. This act specifically prohibited any court from hearing habeas corpus applications from individuals detained as enemy combatants until after their military trials. President Abraham Lincoln also suspended habeas corpus during the Civil War. Initially, in 1861, he suspended it in Maryland and parts of the Midwest in response to secessionist activities and security threats related to the rebellion. This suspension was a response to the threat posed by secessionists and those who resisted Union efforts, including actions that hindered volunteer enlistments and military drafts. On September 24, 1862, Lincoln extended the suspension nationwide to address broader insurgent activities and ensure Union security. Again, Article 1, Section 9, Clause 2 of the U.S. Constitution, habeas corpus. Now, Supremacy Clause 1788. The Supremacy Clause, found in Article 6, Clause 2 of the United States Constitution, was written during the Constitutional Convention in 1787 and enacted when the Constitution was ratified in 1788. It establishes that the Constitution, federal laws made pursuant to it, and treaties made under its authority constitute the supreme law of the land, thus making federal law paramount to state laws. Again, Supremacy Clause 1788. Now, First Amendment 1791, text. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Again, First Amendment 1791 text. Now, Marbury v. Madison, 1803. Marbury v. Madison was a landmark Supreme Court case that established the principle of judicial review, granting the Supreme Court the power to declare an act of Congress unconstitutional. The case arose when William Marbury sued Secretary of State James Madison for not delivering his commission as a federal judge. Chief Justice John Marshall's opinion had significant implications, solidifying the court's role as the final authority on the meaning of the Constitution and setting a precedent for the balance of power among the branches of the federal government by affirming the judiciary as an equal branch alongside the legislative and executive branches. Again, Marbury v. Madison, 1803. Now, Dred Scott v. Sanford, 1857. Dred Scott v. Sanford was a landmark Supreme Court case arising from Dred Scott, an enslaved black man who sued for his freedom after living in free territories with his owner, which he said should emancipate him given those territories were either free states or states that did not allow slavery. The court ruled that black individuals, whether enslaved or free, could not be American citizens and thus had no standing to sue in federal court. Additionally, the decision declared the Missouri Compromise, a law that prohibited slavery in certain U.S. territories, unconstitutional. This ruling effectively meant that black individuals had no legal rights or protections under the U.S. Constitution, exacerbating sectional tensions and contributing to the onset of the Civil War by reinforcing the legality of slavery in U.S. territories. Again, Dred Scott v. Sanford, 1857. Now, the Reconstruction Amendments. 13th Amendment, 1865, Abraham Lincoln, Republican. While the Emancipation Proclamation ended slavery in the Confederacy, the 13th Amendment abolished slavery in the entirety of the United States. It also granted Congress the right to enforce this with appropriate legislation should states defy the ordinance. 14th Amendment, 1868, Andrew Johnson, Democrat. This amendment ensured the Bill of Rights applied to all citizens of the United States of America regardless of race. After Congress passed the Civil Rights Act of 1866, which declared all persons born in the United States to be citizens, without distinction of race or color, or previous condition of slavery or involuntary servitude, they realized they needed a firmer legal precedent to enforce the due process of law, equal protection of the laws, and so on within states. The 14th Amendment allowed the federal government to challenge state governments when they abridged the immunities and rights of citizens on the basis of race. It effectively overturned the Supreme Court's Dred Scott decision by declaring everyone born on United States soil, including black men and former enslaved people, citizens endowed with all the entailed rights. 15th Amendment, 1870, Ulysses S. Grant, Republican black men, could not vote in all states until Congress passed and ratified the 15th Amendment. The stipulation secured voting rights for black men, making it illegal to refuse them the right to vote on account of race or previous condition of servitude. Again, the Reconstruction Amendments. Now, Civil Rights Act of 1875. The bill guaranteed all citizens, regardless of color, access to accommodations, theaters, public schools, churches, and cemeteries. The bill further forbids the barring of any person from jury service on account of race, and provided that all lawsuits brought under the new law would be tried in federal, not state, courts. It stated that all persons within the jurisdiction of the United States shall be entitled to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement, subject only to the conditions and limitations established by law, and applicable alike to citizens of every race and color, regardless of any previous condition of servitude. Radical Republican Senator Charles Sumner of Massachusetts introduced the Civil Rights Act, but he died in 1874 before the bill was law. The Supreme Court declared the law unconstitutional in 1883. In a consolidated case, known as the Civil Rights Cases, the court found that the 14th Amendment to the Constitution granted Congress the right to regulate the behavior of states, not individuals. The decision foreshadowed the 1896 Plessy v. Ferguson decision, in which the court found that separate but equal facilities for blacks and whites were constitutional. Again, Civil Rights Act of 1875. Now, Nix v. Hedden, 1893. Nix v. Hedden was a Supreme Court case involving the classification of tomatoes under tariff laws. The dispute arose when John Nix, a produce importer, argued that tomatoes should be classified as fruits, which were subject to lower tariffs rather than vegetables. The court unanimously ruled that tomatoes should be classified as vegetables based on their common culinary use, which led to higher import tariffs. Judge Horace Gray even said that tomatoes were technically a fruit, but that is not how everyone perceives them. This unanimous decision effectively reinforced the use of common understanding over botanical definitions in legal contexts, impacting tariff regulations and commercial practices. Again, Nix v. Head in 1893. Now, the Tillman Act of 1907. The Tillman Act, the first major campaign finance law, barred corporations and national banks from making contributions to federal election campaigns. Again, the Tillman Act of 1907. Now, the 17th Amendment 1913. The 17th Amendment to the U.S. Constitution, ratified in 1913, established the direct election of U.S. senators by the voters of the states, replacing the previous system where senators were chosen by state legislatures. This amendment aimed to reduce corruption and increase democratic representation. Again, the 17th Amendment 1913. Now, Eugene V. Debs 1919. Eugene V. Debs was a prominent American socialist political activist and five-time presidential candidate for the Socialist Party of America. The context of Debs' speech was during World War I, a time when the U.S. government was intensely focused on rallying support for the war effort and suppressing dissent. On June 16, 1918, in Canton, Ohio, Debs delivered a speech criticizing the war, condemning the U.S. government's involvement, and urging resistance to the draft. He argued that the war was being fought for the benefit of the capitalist class at the expense of the working class. Following his arrest and conviction under the Espionage Act, Debs was sentenced to 10 years in prison. From prison, Debs continued to advocate for socialism and workers' rights. Remarkably, he ran for president in the 1920 election from his prison cell, garnering nearly 1 million votes, which was around 3%. His imprisonment led to the May Day riots of 1919. Again, Eugene V. Debs, 1919. Now, Schenck v. United States, 1919. Schenck was arrested for passing out pamphlets telling individuals to not enlist in the draft. The Supreme Court found that, given the circumstances, passing the pamphlets was against the law because it interfered in the military draft, which was illegal under the Espionage Act. It gave way to the famous "Don't Say Fire in a Crowded Building" saying. It paved the way for the clear and present danger test, which features two independent conditions. First, the speech must impose a threat that a substantive evil might follow. And second, the threat is a real, imminent threat. This test has been used in future court cases like Brandenburg v. Ohio, 1969, again Schenck v. United States, 1919. Now, Buck v. Bell, 1927. Buck was viewed as incompetent and as an individual who should not have children. The Supreme Court agreed and set a precedent for collective welfare outweighing the individual's welfare. Again, Buck v. Bell, 1927. Now, Education v. Barnett, 1943. West Virginia State Board of Education v. Barnett was a landmark Supreme Court case that ruled that compelling public school children to salute the flag and recite the Pledge of Allegiance violated the First Amendment. The decision established that the government cannot force individuals to express certain beliefs, respecting the freedom of speech. It affirmed the principle that the Constitution protects individuals from being compelled to express opinions they do not hold. Again, Education v. Barnett, 1943. Now, Korematsu v. United States, 1944. Korematsu v. United States was a Supreme Court case that upheld the internment of Japanese Americans during World War II, deeming it justified by military necessity. Its implications include a widely criticized violation of civil liberties and a reminder of the importance of protecting individual rights during times of national crisis. Again, Korematsu v. United States, 1944. Now, Taft-Hartley Act. The Taft-Hartley Act of 1947 banned unions from directly contributing to federal campaigns, forcing them to navigate restrictions through alternative means like forming PACs. Again, Taft-Hartley Act. Now, Plessy v. Ferguson, 1896, and Brown v. Board of Education, 1954. Plessy boarded the white part of a train even though he was black. The Supreme Court ruled that this was illegal, and the practice of keeping blacks and whites segregated was legal under separate but equal. Brown v. Board of Education's ruling said that racial segregation was illegal in schools, even if they were equal. Again, Plessy v. Ferguson, 1896, and Brown v. Board of Education, 1954. Now, the Johnson Amendment. The Johnson Amendment, enacted in 1954, prohibits 501(c)(3) non-profit tax-exempt organizations, including churches, charities, and educational institutions, from endorsing or opposing political candidates. Violation of this rule can result in the loss of their tax-exempt status. Again, the Johnson Amendment. Now, 23rd Amendment, 1961. The 23rd Amendment to the U.S. Constitution, ratified in 1961, grants Washington, D.C. the right to participate in presidential elections by providing the district with 3 electors in the Electoral College. This amendment allows D.C. residents to vote for president and vice president but does not grant them representation in Congress. Again, 23rd Amendment, 1961. Now, Brady v. Maryland, 1963. Brady v. Maryland was a Supreme Court case where the court ruled that the prosecution must turn over all exculpatory evidence to the defense. The case involved John Brady, who was convicted of murder after the prosecution withheld a confession by his accomplice that could have potentially exonerated him. The court held that suppression of such evidence violates the Due Process Clause of the 14th Amendment. This decision established the Brady Rule, requiring that the prosecution disclose any evidence favorable to the accused that is material to guilt or punishment. Again, Brady v. Maryland, 1963. Now, New York Times v. Sullivan, 1964. New York Times v. Sullivan was a Supreme Court case that established the actual malice standard for defamation cases involving public officials. The case arose when L.B. Sullivan, a public official in Alabama, sued the New York Times for libel over an advertisement criticizing the police department's actions during the civil rights movement. The court ruled in favor of the Times, stating that for a public official to win a defamation suit, they must prove that the false statement was made with actual malice, a legal standard meaning with knowledge that it was false or with reckless disregard of whether it was false or not. This decision significantly strengthened First Amendment protections for freedom of speech and the press. Again, New York Times versus Sullivan, 1964. Now, 24th Amendment, 1964. The text of the 24th Amendment is as follows. The right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president, or vice president, or for senator or representative in Congress, shall not be denied or abridged by the United States or any state by reason of failure to pay poll tax or other tax. The 24th Amendment abolished poll taxes in federal elections, removing a financial barrier that had disenfranchised black and poor voters, strengthening democracy, and paving the way for broader voting rights protections. Again, 24th Amendment, 1964. Now, Voting Rights Act of 1965. The Voting Rights Act of 1965 was federal legislation that aimed to eliminate racial discrimination in voting by prohibiting practices such as literacy tests and providing federal oversight of voter registration in areas with a history of discriminatory practices. It significantly expanded voting rights for African Americans and other minority groups in the United States. Again, Voting Rights Act of 1965. Now, Griswold v. Connecticut, 1965. Griswold v. Connecticut was a landmark Supreme Court case that established the right to privacy within marriage under the Due Process Clause of the 14th Amendment. The decision invalidated a Connecticut law that prohibited the use of contraceptives, asserting that individuals have the right to make private decisions regarding intimate matters. This case laid the foundation for subsequent decisions, including Roe v. Wade, 1973, which extended the right to privacy to a woman's decision to have an abortion. Again, Griswold v. Connecticut, 1965. Now, Brandenburg v. Ohio, 1969. Brandenburg, a KKK rally leader, made a vague threat toward the government. He was arrested. His case was dismissed by the Supreme Court of Ohio without an opinion, but the Supreme Court voted in Brandenburg's favor, saying his action was unlikely to call for violence. Thus, the Brandenburg test was born, saying speech can be banned if it is both directed at creating lawless action and likely to produce this action. Again, Brandenburg v. Ohio, 1969. Now, the Federal Election Campaign Act of 1971. The Federal Election Campaign Act also provided the basic legislative framework for separate segregated funds, more commonly known as political action committees. Although the law prohibits corporations and unions from making direct contributions to federal candidates, it allows a group to establish, operate, and solicit voluntary contributions for the organization's political action committee. These funds can then in turn be used in federal elections. The Federal Election Campaign Act established disclosure reporting requirements for candidate committees, political party committees, and political action committees participating in federal election activities. Although reporting schedules and thresholds have been adjusted by subsequent legislation, the basic disclosure structure introduced in the Federal Election Campaign Act remains in force to the present day. As originally enacted, the law did not provide for a single regulatory agency. Instead, administrative responsibilities were divided between the Clerk of the U.S. House of Representatives, the Secretary of the U.S. Senate, and the Comptroller General of the U.S. General Accounting Office. Again, the Federal Election Campaign Act of 1971. Now, the 26th Amendment. The 26th Amendment to the United States Constitution, ratified in 1971, lowered the minimum voting age from 21 to 18, granting millions of young Americans the right to vote. The 26th Amendment was ratified to lower the voting age because of the Vietnam War. Many argued that if young adults were old enough to be drafted and fight in the war, they should also have the right to vote. Again, the 26th Amendment. Now, Roe v. Wade, 1973. Roe v. Wade was a landmark Supreme Court case that legalized abortion nationwide. The decision established a woman's legal right to have an abortion under the Due Process Clause of the 14th Amendment. It divided pregnancy into 3 trimesters, with states allowed to regulate abortion in the 2nd trimester and restrict it in the 3rd based on the viability of the fetus. In no case, however, could the state criminalize abortions that were necessary to protect the life or health of the pregnant person. Again, Roe v. Wade, 1973. Now, the 1974 Amendment to the Federal Election Campaign Act of 1971. In the aftermath of the Watergate scandal, Congress approved a series of significant amendments to the Federal Election Campaign Act. Perhaps most notably, these amendments created the Federal Election Commission. Congress vested the commission with the authority to administer and enforce the Federal Election Campaign Act. The commission comprises 6 members, all of whom are appointed by the President with the advice and consent of the U.S. Senate. No more than 3 members of the commission can belong to the same political party, and at least 4 votes are required for any official commission action. 2 seats come up for appointment every 2 years. The 1974 amendments established contribution and spending limits. In 1976, the Supreme Court ruled in Buckley v. Valeo that spending limits violated the Constitution's First Amendment. Again, the 1974 amendment to the Federal Election Campaign Act of 1971. Now, Buckley v. Valeo, 1976. First, the Supreme Court held that restrictions on individual contributions to political campaigns and candidates did not violate the First Amendment, since the limitations of FECA enhance the integrity of our system of representative democracy by guarding against unscrupulous practices, such as quid pro quo. Second, the court found that governmental restriction of independent expenditures in campaigns, the limitation on expenditures by candidates from their own personal or family resources, and the limitation on total campaign expenditures did violate the First Amendment. Since these practices do not necessarily enhance the potential for corruption that individual contributions to candidates do, the court found that restricting them did not serve a government interest great enough to warrant a curtailment on free speech and association. Again, Buckley v. Valeo, 1976. Now, University of California v. Bakke, 1978. In the case of Regents of the University of California versus Bakke, the Supreme Court ruled that while quotas were unconstitutional, race could be used as one of several factors in college admissions. This decision had significant implications for affirmative action policies in higher education, allowing universities to consider race as a factor in achieving a diverse student body under the constraints of the 14th Amendment's Equal Protection Clause. Again, University of California v. Bakke, 1978. Now, Texas v. Johnson, 1989. In Texas versus Johnson, the Supreme Court established that the act of burning the American flag, although deeply controversial and offensive to many, constitutes a form of symbolic expression. Symbolic speech refers to the use of nonverbal acts or symbols to convey a particular message or statement. By recognizing flag burning as a protected form of symbolic speech, the court emphasized that the First Amendment not only safeguards verbal and written expression, but also extends to expressive actions that communicate ideas, values, or dissent in a nonverbal manner. Again, Texas v. Johnson, 1989. Now, National Voter Registration Act of 1993. The National Voter Registration Act of 1993, also known as the Motor Voter Act, aimed to facilitate voter registration by requiring states to provide registration opportunities at motor vehicle departments. States must also designate other agencies as voter registration sites, which can include public libraries, schools, colleges, and various government offices, though this is at the state's discretion. Again, National Voter Registration Act of 1993. Now, Section 230, a provision of the Communications Decency Act of 1996, which is part of the broader Telecommunications Act of 1996. Section 230C1. This clause states that online platforms are not to be treated as the publisher or speaker of content provided by another user, protecting them from liability for user-generated content. Section 230C2. This clause grants platforms immunity from civil liability for good faith efforts to moderate and remove content they deem objectionable, even if that content is constitutionally protected. Again, Section 230, a provision of the Communications Decency Act of 1996, which is part of the broader Telecommunications Act of 1996. Now, Bush v. Gore 2000. Bush v. Gore was a landmark Supreme Court case that effectively decided the outcome of the 2000 United States presidential election. The decision halted a recount of disputed ballots in Florida, effectively awarding Florida's electoral votes and the presidency to George W. Bush. The decision to halt the recount of disputed ballots in Florida was based on the argument that the recount process was not being conducted with equal protection of the law, violating the 14th Amendment because it gave preferential treatment to some ballots over others on account of Gore deciding which counties to do recounts in. The case was controversial due to issues such as faulty ballot design, unclear voter intent, and the Supreme Court's intervention, which some argued influenced the outcome of the election. Again, Bush v. Gore 2000. Now, Bipartisan Campaign Reform Act of 2002 BCRA. BCRA, commonly called the McCain-Feingold Act, is a major federal law regulating financing for federal political candidates and campaigns. The law was designed to address two key campaign finance issues: soft money and issue advocacy. The Bipartisan Campaign Finance Reform Act raised contribution limits for individuals and select political committees to federal candidates, also referred to as hard money. Some of these limits were also indexed to inflation. These limits were set to be adjusted during odd-numbered years. The law prohibited national political parties, federal candidates, and office holders from soliciting soft money contributions, which are funds generally perceived to influence elections but not regulated by campaign finance law in federal elections. Before BCRA was enacted, this included large contributions from otherwise prohibited sources, which went to party committees for party-building activities that indirectly supported elections, like issue advocacy, which is advocating for positions on particular issues, not express advocacy, which is directly advocating for a candidate. McCain-Feingold barred corporations and unions from using their treasury funds to finance issue advertisements, sometimes called electioneering communications, which are defined as broadcast ads referring to clearly identified federal candidates within 60 days of a general election or 30 days of a primary election or caucus. In 2010, the United States Supreme Court ruled in Citizens United v. Federal Election Commission that this provision was unconstitutional. Again, Bipartisan Campaign Reform Act of 2002 BCRA. Now, Help America Vote Act, 2002. The Help America Vote Act appropriated federal funds to be dispersed to the states for the purpose of updating voting equipment and election administration procedures. Title II established the Election Assistance Commission, which was charged with assisting the states regarding HAVA compliance and distributing HAVA funds to the states. The commission was also tasked with maintaining the National Voter Registration Form, conducting research, and administering a national clearinghouse on elections that includes shared practices, information for voters, and other resources to improve elections. The law mandated that any new registrant must provide either a driver's license number or the last 4 digits of his or her social security number at the time of registration. Again, Help America Vote Act, 2002. Now, the Stand By Your Ad provision of BCRA 2002. Both authorized and unauthorized television communications must contain a clearly readable written statement that appears at the end of the communication, for a period of at least 4 seconds, with a reasonable degree of color contrast between the background and the disclaimer statement. The written statement must occupy at least 4% of the vertical picture height. In addition to the requirements already noted, radio and television communications, or any broadcast, cable, or satellite transmission that are authorized or paid for by a campaign require additional language. For such ads, the candidate must deliver an audio statement identifying themselves and stating that the candidate has approved of the communication. For example, I am candidate's name. A candidate for federal office saw it, and I approved this advertisement. In a television ad, the disclaimer must be conveyed by a full-screen view of the candidate making the statement or a voiceover by the candidate with an image of the candidate occupying no less than 80% of the vertical screen height. A radio or television communication that is not authorized by a candidate or the candidate's authorized committee must include an audio statement from a representative of the political committee, corporation, labor organization, individual, or group paying for the communication that blank is responsible for the content of this advertising, where blank is the name of the political committee, corporation, labor organization, individual, or group who paid for the communication. This is in addition to the statements identifying who paid for the communication, and that it is not authorized by any candidate or candidate's committee. Again, the Stand By Your Ad provision of VCRA 2002. Now, DC v. Heller, 2008. In a 4-5 decision, the Supreme Court ruled that it was unconstitutional to prevent someone from owning a gun for things like self-defense. Because of the Second Amendment, it was illegal in DC to own a gun in one's home. The dissent said that the Second Amusement spoke to armed forces and militias, not for civilian use. Again, DC v. Heller, 2008. Now, Citizens United v. Federal Election Commission, 2010. The case FEC v. Citizens United arose from the Bipartisan Campaign Reform Act, VCRA, of 2002, which aimed to regulate campaign finance by banning corporations and unions from using their general treasury funds for electioneering communications within 30 days of a primary or 60 days of a general election. Citizens United, a conservative nonprofit, sought to air a film critical of Hillary Clinton during the 2008 Democratic primary, which fell under BCRA's restricted period. Anticipating legal issues under BCRA, Citizens United preemptively challenged the FEC to prevent the application of these restrictions. The Supreme Court Citizens United v. Federal Election Commission 2010 decision had a significant implication by allowing increased corporate and union spending in political campaigns, citing free speech protection. This ruling paved the way for the rise of super PACs, which are independent expenditure committees that can spend unlimited amounts of money in support of political candidates or causes, further influencing the political landscape. Again, Citizens United v. Federal Election Commission 2010. Now, Snyder v. Phelps 2011. Snyder v. Phelps was a landmark Supreme Court case that upheld the Westboro Baptist Church's right to picket military funerals with extremely offensive signs, citing freedom of speech protections under the First Amendment. The decision highlighted the importance of protecting even highly offensive speech in public forums, setting a significant precedent for free speech rights. It underscored the principle that public discourse often protects even the most controversial expressions. Again, Snyder v. Phelps 2011. Now, Fisher v. UT Austin 2012. Fisher was a white student who applied to UT Austin and claimed race-conscious policies kept her out of UT Austin. The Supreme Court said it was okay to consider race in admission policies. The decision had implications for college admissions, allowing universities to consider race as one of many factors in achieving a diverse student body. Again, Fisher v. UT Austin 2012. Now, Shelby County v. Holder 2013. Shelby County v. Holder was a Supreme Court case where the court invalidated key provisions of the Voting Rights Act of 1965, particularly Section 4B, which contained the coverage formula determining which jurisdictions required federal preclearance before changing voting laws. This preclearance requirement, outlined in Section 5 of the Act, mandated that certain states and local governments with a history of discrimination obtain federal approval before implementing any changes to their voting procedures. The Supreme Court ruled that the coverage formula was outdated and therefore unconstitutional, as it no longer reflected current voting conditions. The decision significantly weakened federal oversight of state election laws, leading to concerns about increased voter suppression and discriminatory practices, as states previously subject to preclearance could now change voting laws without federal approval. Again, Shelby County v. Holder 2013. Now, McCutcheon v. FEC 2014. In McCutcheon v. FEC, the Supreme Court struck down aggregate limits on individual contributions to federal candidates, political parties, and political action committees. The decision allowed individuals to contribute to as many candidates and committees as they wished, so long as they did not exceed the base limits for each recipient. This ruling expanded the influence of wealthy donors in federal elections, asserting that aggregate contribution limits violated the First Amendment's protections of political speech and association. Again, McCutcheon v. FSC 2014. Now, Masterpiece Cake Shop v. Colorado Civil Rights Commission 2018. Masterpiece Cake Shop vs. Colorado Civil Rights Commission was a Supreme Court case that ruled in favor of a baker who refused to make a wedding cake for a same-sex couple on the grounds of religious beliefs. The case highlighted the tension between anti-discrimination laws and religious freedom. But it didn't establish a precedent on the broader issue of whether businesses can refuse services to LGBTQ+ people based on religious beliefs. Again, Masterpiece Cake Shop v. Colorado Civil Rights Commission 2018. Now, Rucho v. Common Cause 2019. Rucho v. Common Cause was a Supreme Court case where the court ruled that partisan gerrymandering is non-justiciable, meaning federal. Courts cannot decide on them because they are political questions, which are issues more appropriately handled by elected branches rather than the judiciary. This decision leaves the regulation of partisan gerrymandering to state courts and legislatures. The ruling allows political parties more leeway in drawing electoral districts to their advantage without federal court intervention. Again, Rucho v. Common Cause 2019. Now, Dobbs v. Jackson Women's Health Organization 2022. Dobbs v. Jackson Women's Health Organization was a Supreme Court case that challenged the constitutionality of a Mississippi law banning most abortions after 15 weeks of pregnancy. The central question was whether all pre-viability prohibitions on elective abortions are unconstitutional. The Supreme Court's decision in Dobbs overturned Roe v. Wade, 1973, and Planned Parenthood v. Casey, 1009, 192, the two key precedents that had previously established and reaffirmed a constitutional right to abortion before fetal viability, generally around 24 weeks of pregnancy. The court held that the Constitution does not confer a right to abortion, thereby returning the authority to regulate abortion to individual states. This ruling significantly altered the legal landscape of abortion rights in the United States, allowing states to impose stricter regulations or outright bans on abortion, leading to a patchwork of abortion laws across the country. Again, Dobbs v. Jackson Women's Health Organization 2022. Now, Texas SB 17. As of April 14, 2024, SB 17 requires the governing board of a public institution of higher education to ensure that each unit of the institution does not, except as required by federal law or otherwise provided by the bill's provisions, do the following: establish or maintain a DEI office, hire or assign an employee of the institution or contract with a third party to perform the duties of a DEI office, compel, require, induce, or solicit any person to provide a DEI statement or give preferential consideration to any person based on the provision of a DEI statement. Give preference on the basis of race, sex, color, ethnicity, or national origin to an applicant for employment, an employee, or participant in any function of the institution. Require any person, as a condition of enrolling at the institution or performing any institution function, to participate in DEI training. SB 17 does not apply to academic course instruction, scholarly research or a creative work by a public institution of higher education students, faculty, or other research personnel, or the dissemination of that research or work. An activity of a student organization registered with or recognized by a public institution of higher education. Guest speakers or performers on short-term engagements. A program or activity to enhance student academic achievement or postgraduate outcomes that allows participation without regard to race, sex, color, or ethnicity. Data collection. Student recruitment or admissions. Again, Texas SB 17, due as of April 14, 2024. Now, Trump v. United States, 2024. The nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. He is also entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. Again, Trump versus United States, 2024.